Hi everyone, welcome. Thanks for coming to my talk. Please let me know if you have problems listening to me or like looking at the screen. Otherwise, I think I'm going to start. Okay. So today I am going to talk about just a brief talk on introduction to franchise law in Malaysia. Okay. Okay, so this is like a rough outline about what I'm going to talk about today. So firstly, it will be like the basic terms and conditions of the franchise agreement, the registration of the franchise in Malaysia, effects of failing to register a franchise in Malaysia, and the differences between a franchise and a license, and case study of Malaysian franchise cases, and Q&A is the last one. So for case study, right, I am just kind of consolidating it together with topic number 3 and number 4. So I'll just study the cases together with those. Okay, I'm going to move on. Okay, firstly, what is a franchise agreement? So in simple terms, a franchise is a method of distributing products or services involving a franchisor who establishes the brand's trademark and business system, and a franchisee who pays royalty to the right to do business under the franchisor's name and system. So basically, the franchisor will set up a system and their trademarks and everything, and they will then franchise it to the franchisees, and the franchisee will have to pay royalty in order to operate the franchise as a franchisee. Sorry, I'm just trying to, I think I should start from the beginning because there's suddenly a lot of people joining. Yeah, so anyway, just go back a little bit. This will be my outline for today's talk. And I was just on the first slide on explaining of what a franchise in simple terms. So I'll move on. Okay, in legal terms, under the Franchise Act, a franchise is defined to mean an agreement, regardless of oral or written, where the franchisor grants to the franchisee a right to operate a business according to the franchise system that the franchisor has already established. And it is also where a franchisor grants to the franchisee the right to use a trademark or IP rights owned by the franchisor. The franchisor will also possess some level of control over the franchisee throughout the franchise term. So the franchisee cannot modify the franchise trademark or start selling different products. So this is the kind of control that the franchisor will have over the franchisee. And in return of these rights that the franchisee now has, the franchisee will be required to pay a fee to the franchisor. And this is more commonly known as a royalty. So please just let me know if you have any questions. You have to unmute yourself so that I can hear you. Okay, otherwise I'll just keep going on. For the first subtopic, it will be on the terms and conditions of a franchise agreement. Okay, the Franchise Act requires a franchise agreement to contain a minimum content, and this is under section 18 sub 2 of the Franchise Act. It includes the name and description of the franchise, the territorial rights of franchisee, and the obligations of franchisor and franchisee, a statement on the cooling off period, and the description of trademark and any other IP rights to be used. So I just want to talk a bit more on this statement on cooling off period because I think it's quite special, and I've only seen this in a franchise agreement. So on that part, I'll be explaining more later. I just wanted to highlight to you first. Okay, so now that we know that there is this minimum amount of content that must be in the franchise agreement, so what happens if you don't fulfill this minimum content? Under section 18 sub 3, your agreement will be rendered null and void. However, there is a new Franchise Amendment Act, which has just recently been gazetted, but it is not yet enforced. So the Amendment Act will delete this section 18 sub 3. So if you don't fulfill the minimum content, your agreement will no longer be null and void. So that is the effect. But then I just want to stress again that this Amendment Act is not yet enforced. And I think it was gazetted in March. So I think it should be enforced soon. And so regardless of whether section 18 sub 3 is deleted or not, a person who does not include this minimum content commits an offense, and this is under section 14 sub C in the Amendment Act. Okay, I will be moving on. Okay, now the Franchise Act also requires the agreement to be drafted in a certain way. So while the Act does not say that these obligations must be in, but when you do the registration, they will ask you to specify where in your franchise agreement has this content. Okay, so the first one is that the franchise agreement must be in writing. Now, this is interesting because in the definition of a franchise under the Franchise Act, a franchise can be oral or in writing. But when you look at section 18 sub 1, it must be in writing. So it's just interesting to note this. Okay, and number 2 is the cooling off period, which shall not be less than 7 days. So during this cooling off period, the franchisee has the option to terminate the franchise agreement, and the franchisor has to refund all money that has been paid back to the franchisee, except for an amount reasonable to cover the expenses incurred by the franchisor to prepare the agreement. So let's say if I am a franchisor and I enter into a franchise agreement with you, you will have a cooling off period of 7 working days. So during these 7 working days, if you decide to not go through with the franchise, then you can terminate and there should be no repercussion. But I will have to charge you some small amount of money to cover my cost in preparing the agreement. And all other money that you have paid to me must be refunded to you. So some examples of this kind of money would be maybe a deposit or paid upon signing, things like that, or I must refund to you. So this is the cooling off period, and this must be in the franchise agreement according to the Franchise Act. Okay, I will move on. Okay, the third key notable requirement is that a franchisor is required to register his trademark with our Malaysian MyIPO before they apply for the registration of franchise. So it is not enough if they have registered their trademark in another jurisdiction. That's not enough. They must register it in Malaysia, and it should be with MyIPO. So when you apply with MyIPO, you will have a cert of registration, and this cert you have to submit to the registrar of franchise. And number 4, the franchise term must not be less than 5 years. So a franchise agreement cannot be for 4 years or 3 years. It must be 5 years or more. Yeah. Okay. Number 5, franchisee is required to provide a written guarantee to the franchisor that the franchisee, including his director, spouse, and immediate family, or his employees, he must guarantee that they will all not disclose to any person of the franchise trade secrets during the franchise term and for 2 years after the expiration or termination of the franchise agreement. Okay, I will move on. The number 6 is franchisee must also provide a written guarantee that the franchisee and his affiliates shall not compete with the franchise business during the franchise term and for 2 years after the termination. So this is a non-compete clause, but what is interesting is that non-competes are usually, it could be a restraint of trade. And generally, restraint of trade is void under Section 28 of the Contracts Act. But if you look at the application clause of the Franchise Act, it says that if there is any conflict between the Franchise Act and any other written laws, the provisions of the Franchise Act shall prevail. So this means that while the Contract Act says that you cannot restrain people from trading or like doing their business, but the Franchise Act says that you cannot compete with the franchise. So the Franchise Act will prevail. Okay, I hope I'm clear. Okay, then I'll move on to point 7. So point 7 is that parties cannot agree to waive compliance with the Franchise Act, and if there is such terms in the franchise agreement, these terms will be void. So I cannot agree with my franchisee that, oh, we don't need to follow the Franchise Act. They cannot, it will be void. And this just shows how the Franchise Act protects the franchisor and the franchisee. I'll move on. Okay, if there is a breach by the franchisee, the franchisor must give a written notice and allow the franchisee to remedy, and this notice must be at least 14 days. So within these 14 days, you must remedy the breach. So this shows how the Franchise Act protects the franchisee. So you cannot just fault me for any breach. You must give me a chance to remedy it. Okay. Now, number 9. The franchisor is also obligated to provide assistance to a franchisee to operate the franchise business, and this includes like a provision or supply of materials and trainings. So this one just imposes a contractual obligation on the franchisor to train the franchisee and to provide assistance to the franchisee. So the franchisor cannot just sell the franchise and ignore the franchisee. They are then contractually bound to help out with the franchise business with the franchisee. I will move on. Okay, point number 10. A franchisor and franchisee cannot terminate the franchise agreement before expiration except for good cause. So examples of good cause can be found in the Franchise Act, and it includes failure to remedy a breach even after due notice is given. It also includes situations where no notice is required, and some examples will be bankruptcy or winding up or abandonment of the franchise business. So if any of this happens, it will be good cause, and you can terminate the franchise agreement prior to the expiration. Okay, and I go to point 11 now. A franchisee may, at his option, apply for an extension by giving a written notice to the franchisor of not less than 6 months prior to the expiration. So a franchisee has like an option to extend the franchise agreement if he wants to. Point number 12, if such franchise agreement is extended, the conditions in the new franchise agreement cannot be less favorable than the conditions in the previous franchise agreement. So let's say if I want to extend the franchise agreement, you cannot force me to accept terms that are less favorable than what we already have. I will move on. So I come to the second part now, which is registration of a franchise in Malaysia. So under the Franchise Act, registration is required, and I'll just talk a bit on what types of registration there are and a rough idea on how we go about it. Okay, so firstly, who do we register with? Now, registration is made with the Registrar of Franchise, and the government authority currently handling franchise registration is the Ministry of Domestic Trade and Consumer Affairs. So it's MDTCA. Okay, there are 5 types of registrations required under the Franchise Act, and they are as follows. So the first one is the registration of a local franchisor. So if I sell the franchise, I am the franchisor, local franchisor, and local master franchisee. So master franchisee basically means, let's say I get a franchise from the US. Let's say I get the McDonald's franchise, and I'm telling my foreign franchisor that I will handle all the franchises in Malaysia. So then the foreign franchisor will franchise to me, and I will sub-franchise to all the smaller franchisees in Malaysia. So then I will be the master franchisee. Can you guys still hear me? Because I just got a part that says my internet is not stable. Okay. Okay, so the first one is section 6. Now the second one is the registration of a franchisee of a foreign franchise. So like the example I gave just now, if I get the McDonald's franchise from a US franchisor, I will become the franchisee of a foreign franchisor. Okay, so that is 6A. And number 3 is franchisee of a local franchisor. Okay. Thanks, Alicia. Okay. Number 3 is franchisee of a local franchisor. So in the McDonald's situation that I gave an example just now, if I then sub-franchise to a smaller franchisees in Malaysia, those franchisees will be franchisee of a local franchisor because I then become, I'm then the local franchisor. So that is 6B. And number 4, foreign franchisor, the party from US is the foreign franchisor. And number 5, the franchise consultant or franchise broker. So this is under section 14. Now, franchise consultant or broker, they are not really part of the chain, but they help out with the franchising and the registration. So these people are also required to be registered under section 14. Move on. Okay, so this is just how it looks like when you submit your online registration. So you can see that these are the forms that are available. And I wanted to point out that section 6, there are 2 types of forms because there is the local franchisor and the master franchisee. So let me just go back and then you can see that local franchisor and local master franchisee. So you can see that there's 2 forms under section 6. And then the rest is 1 form each. Okay, I'll move on. Okay, so I want to talk about the first one, which is section 6. Who does this apply to? It applies to a local franchisor company or a local master franchisee of a foreign franchisor. Now, what is required to be submitted is, you can find this in the registration handbook. It says that the company must be registered with CCM as a Sendirian Berhad. So you cannot be a Berhad or like, you must be Sendirian Berhad. That is the requirement. And you must have at least operated for 3 years and have prepared 3 years audited accounts. I will talk more about this later. This is an interesting point. And you must have a premise or prototype outlet. Just give me 1 minute. Okay, sorry, I think I forgot to admit 3 of you just now. I'm so sorry. But I'm already like halfway, so I'm just gonna continue. Okay, I'll give you guys the slides later. Okay, sorry, I was just saying that what are the key requirements for registration of under section 6 of a local franchisor or master franchisee. So you must have operated for at least 3 years and prepared 3 years of the account. So this one, you just remember first, later I'll talk more about it. And then you must have a premise or prototype outlet that has been operating for 6 months, not years, sorry, 6 months. I have to amend that. And you must have prepared a sample franchise agreement. Okay. When to register? So section 6 sub 1 says that a franchisor must register before he can operate a franchise business. But you remember that just now, it says that you must have operated for 3 years. So when you look at it, you kind of feel like there's a disconnect. Actually, it is not really a disconnect. It just means that you must have operated your business as a business and not as a franchise for 3 years first. Then 3 years later, when you want to sell, then you register. But you must remember that the registration must be before you operate the business as a franchise or you sell the franchise to any other person. Okay. I will move on. Okay, then now we come to section 6A, which is a registration of franchisee of a foreign franchisor. Just to explain for those who I did not admit just now, so franchisee is the person who receives the franchise from a franchisor, and a franchisor can be local or foreign, and it must be distinguished because if you are foreign, you are under a different registration. I think the third term was master franchisee. So master franchisee is somebody who will handle the smaller franchises in a territory. So then that person is called a master franchisee, and then they will franchise to the smaller franchisees. Okay, so let me just start on this slide. So 6A applies to a franchisee who has signed a franchise agreement with a foreign franchisor who is registered under 54. So just kind of remember this part, and I'll talk about it more in the next slide. So some key requirements is that the franchisee must be registered with CCM, must have updated its filings with CCM every 6 months, and must have signed the agreement with the foreign franchisor. Okay. So then the question is when to register. 6A1 says that before you commence the franchise business, a franchisee who has been granted a franchise from a registered foreign franchisor must apply to register. So this means that before you sign the franchise agreement and before you commence the franchise business, you must first register. So this is the kind of thing that we have to keep in mind when clients will ask, when do I register, things like that. And it is different for each registration. So you can just refer to these slides if you're not sure. Okay, then I will talk about 6B. This applies to a franchisee who has signed a franchise agreement with any local franchisor or any master franchisee who is registered under Section 6. So the key requirements are roughly the same. It is that you must have signed first. So when to register? Now, under 6B, there is a deadline, which is 14 days from signing, you must register. So because the 14 days is quite tight, there are a lot of documents that you have to submit. So this needs to be planned prior to the signing of the franchise agreement, because 14 days is from the date of signing. So before you sign, you have to plan ahead and like compile all documents required so that after signing, you can straight away submit to our app. Right? So this is the kind of things that you have to keep in mind when advising client on registration timing. I will move on. Okay, next is registration under Section 54, registration of a foreign franchisor. So this registration is actually an approval under Section 54 for foreigners to sell their franchise in Malaysia or to any Malaysians. So some key requirements will be audited accounts for the latest 3 years. And this can be like prepared by foreign auditors since they will be foreigners, and sample franchise agreement and a certificate of incorporation, just to show that this foreign franchisor is established. So again, when does this registration need to happen? So under Section 54, it says that a foreign person who intends to sell shall apply to register. Now, if you read the language in Section 54, coupled with the fact that a sample franchise agreement is required to be submitted. Let me just go back and show you again that sample franchise agreement, you must submit this. So when you intend to sell and you have not signed the franchise agreement, so it's kind of clear that the registration must happen before the signing of the franchise agreement. Okay, so once I want to sell, but I cannot sell yet until I register. And once I'm registered, I can sign off on the franchise agreement that is being like sold out. I'll go on. Now, as I was saying earlier, there is the new amendment of the Franchise Act in 2020. But let me just stress again that it's not yet enforced, but it's gazetted. So once the Amendment Act comes into force, foreign franchisor will be required to register twice. Firstly, under Section 54, and secondly, under Section 6.1. So Section 6.1 will be amended to say a franchisor or any foreign person who has obtained approval under Section 54 must register. So then foreign franchisor will have to register twice. Okay. I'll just move on. Okay. Okay, so then the issue is, what if I had registered, then the new amendment came in, So for do I have to register again under Section 6? So for any foreign franchisor who has obtained approval under Section 54, prior to the coming into force of the Amendment Act, they will be deemed to have registered under Section 6(1). So for people who have already obtained Section 54 approval, you don't need to register again under Section 6. So this will only apply for people who have not obtained Section 54 approval. I will move on. Okay, next is the registration of franchise consultant or franchise broker, Section 14. So this applies to a franchise consultant or broker. So a consultant is somebody who advises and provides consulting services to others about registration of franchise and compliance with the relevant franchising law. So if you are somebody who advises and provide consulting services, then you are considered to be a franchise consultant and you must be registered. So actually this kind of applies to our firm because we do advise and provide services about compliance. So I think we have been talking about registering. Yeah, and we will be doing it. And then a franchise broker is somebody who carries on the business as an agent or representative to any franchisor who wants to sell the franchise, but this does not include directors, employees, or officers of the franchisor. So just a broker, if you're a broker, then you must be registered as a franchise broker. But if you are like the director, then you are not a broker because you're just the director. Next, okay, then I'll come to my third chapter now. The effects of failing to register a franchise in Malaysia, and I will complement this with the case studies. So, what happens if I don't register? Now, several cases have established that a failure to register a franchise will render the franchise agreement unlawful, void ab initio, and unenforceable by law. So this is why registration of franchise is extremely important. Otherwise, if you are not registered, your agreement is illegal, is tainted with illegality. Okay, there are two High Court cases who came to this conclusion, and it's T Delights and SP Multitech. I can send you guys the cases later too. Okay, now, once, let's say if my franchise agreement is illegal, then what happens? So Section 66 of the Contracts Act can be invoked if certain parties have received advantages under the illegal agreement. So Section 66 provides for restitution of all benefits and payments received under the illegal franchise agreement, and these payments must be refunded to the relevant parties. So whatever franchise fees you have collected as a franchisor, if you didn't register, you have to pay them back to your franchisee, and parties must be put back to their original positions. So yes, registration is very, very important. I'll move on. Okay, in the case of SP Multitech, which I cited just now, the defendant actually tried to argue that the ROF, the registrar, didn't take any action against them, and it shows that they didn't act illegally under the Franchise Act. However, this argument did not succeed because the High Court judge they just don't agree with this contention, and they said that the ministry or the public prosecutor has the right to initiate a proceeding anytime they want. So just because I didn't sue you doesn't mean that what you have been doing is wrong. Move on now. Okay, now I will also talk about the penalty that is under the sections. So Section 6, any franchisor who fails to register shall be liable to fines, and if you are an individual, you are not a company, you may be liable to imprisonment as well. And if you continue to not register, then it's a subsequent offense, and the penalties are there. So if you're a company, a fine, and if you are an individual, a fine or imprisonment term or both. Penalties under Section 6A, 6B, and 54. Now, there are no specific penalties under these three sections, but it's interesting to note that after the coming into force of the Amendment Act, the Franchise Act will be amended where it will be an offense to not register under Section 6A and 6B. But even with the Amendment Act, there is no specific penalty provided. It just says that you commit an offence if you don't register. Section 54, also there's no specific penalty. So then we fall back on section 37A. So 37A is it penalizes the offence of carrying on a franchise business without registration. So this may apply. On conviction, these are the fines, and if you are an individual, you may be liable to imprisonment. Okay, I will go next. Okay. Penalty under section 14. Now, section 14, if you remember, is for the registration of franchise consultant or broker. So section 14 also, there's no specific penalty, but with the Amendment Act, after it comes into force, there will be a specific penalty, and any person who fails to comply will be liable to a fine. So then I also want to talk about the general penalty, because as you know, if there's no specific penalty, the general penalty in the Act may apply. So the general penalty is in clause 39, and it says that where there is no penalty expressed, these penalties shall apply. So there's imprisonment term as well if you are an individual, and if you are a body corporate, fine. Okay, I will move on. Now, I've seen a case where they have argued that after I've paid my fine, can I kind of rectify my breach of a franchise agreement? So I already paid my fine. What else do you want like that? So in that case, it's the case of Dr. Kramer London. And the council argued that since the FA, the Franchise Act, provides for penalties in fine, does it mean that after payment, the franchise agreement will no longer be affected? The High Court disagreed with this argument, and the High Court held that there is nothing in the Franchise Act that allows for subsequent payment of fine to reinstate the franchise agreement. So the very first slides on the effect, where I talked about what will happen to your franchise agreement if you don't register, would still apply. So your franchise agreement will still be void ab initio, unenforceable, and illegal, even if you have paid the fine after that. Okay, we'll move on. Okay, now I will talk about the differences between a franchise and a license with case studies. So a lot of times, people will ask what is the difference between a franchise and a business, because they are both similar in the sense that they both grant rights. So I will explain. Okay, the main difference is that a license arrangement is not regulated, whereas a franchise is regulated under the Franchise Act. And a license arrangement does not require registration. And a license agreement usually is about a right to use an IP right. So a licensor will usually give a license to the licensee to use its trademark, something like that. Whereas a franchise is about the use of the entire franchise system, and the IP rights is only a part of the entire franchise system. So that is the difference to what is being let use. So a franchise is like the whole business system, including the trademarks and everything. Now move on. And licensor, generally they do not administer the level of control over a licensee as compared with a franchisor would have over a franchisee. So a licensor usually wouldn't say that you must paint your storefront a certain color to be the same as all the rest of the franchise. They usually don't do that. And they usually just give you the right to use a trademark or any IP rights. Whereas in a franchise arrangement, you must have the same storefront as the other franchise. So like KFC is all red, and like McDonald's has that golden arch. So all of these stores must be the same. So that is the kind of control that a franchisor has. Whereas a licensor usually don't have that kind of control. Number 5, parties are free to negotiate on licensing agreement, whereas in a franchise term, there are certain clauses that must be fixed, and this is prescribed under the Franchise Act. So like I said earlier, there are minimum content and protection that you must provide for in your franchise agreement in order to be registered. So whereas in a licensing agreement, there's no such thing. You can just say to agree on anything. So then this really begs the question as to why would I then go for a franchise? Why don't I just call myself a license? Right, since the license is like so free and there's no registration. Okay, so I'll talk about that now. You may not pass an agreement which looks like a franchise and then you package it as a licensing agreement just to avoid being regulated. You cannot do that. You cannot just sign a franchise agreement and then just name it as licensing and argue that I am not a franchise, I am actually a licensing agreement. Now, in the case of Dr. H.K. Fong Brain Builder, the issue is about a master licensing agreement. And the council did argue that they are not a franchise because they are a licensing agreement. The High Court held that the court is not bound by the label or description given by the parties to the agreement. And the court was of the opinion that the Franchise Act applies to the master licensing agreement on the basis that it fulfills 4 out of the 6 conditions found in the definition of a franchise under the Franchise Act. So it is really substance over form. If your agreement is very similar to a franchise, if it fulfills a majority of the conditions to the definition of a franchise, you may be deemed to be a franchise, and thus you may be required to be registered. So really, you cannot just kind of package your agreement to be a licensing and pass it off like. Okay, I'll move on. And that's the end of my presentation. I will now take questions and I will try my best to answer. Please unmute yourself if you have any questions. I will wait maybe like 1 minute.
Gloria?
Yes, hi.
Okay.
And
Hi. Okay, do you know if a client says they just want to call themselves a franchise, but they don't actually want to be a franchise? Is that allowed?
no, because, okay, so if let's say I want to market myself as a franchise, but I then want to argue that I'm not actually a franchise, it is not allowed because in one of the slides, it says that if you carry on the business of a franchise, or if you present yourself to be a franchise, then you must be registered. Otherwise, it's an offense, and you are liable to be penalized. I think it's something like yeah, it's this one. So section 37A says that if you carry on a franchise business without registration, you are liable to these fines and penalties.
Oh, okay. Actually, it's more like because it's just to bring up the discussion. I had a client who came to see me and said that he just wants to market his business as franchise, but he is actually not a franchise, as in his business model is not meant to be a franchise. So he just wants to market it as to make it more attractive to people. So actually the answer, you are right. You can't even say like, or put a billboard or a poster to say that, okay, I'm selling a franchise if you're not registered. Yeah, so that was like my point. Like if anyone were to ask you guys that, okay, can I just do for marketing purposes, I call myself a franchise, that is also not allowed because you can't pass yourself off as a franchise if you are not registered. Okay?
Okay.
Yeah.
Let
actually,
me just,
it's in the Act somewhere as well.
Yeah, actually it is this section 37A. It's just that my slide is a summary of it. But if you can refer to section 37A, it is very, very clear. It says that any person who uses in his business the term franchise or and uses any words that indicate that they are carrying on a franchise, then they will fall under this section 37A. So this is the clause. You just look at it later.
Okay, thank you.
Thank you, Anne. Any more questions? I think there's no more questions. So I'm gonna end the talk. Thank you very much, everyone, for your time. I will be distributing my slides and the materials that I've prepared for your own reading. Thank you. Thank you for your time.
Thank you, Gloria.
Bye-bye.
Bye.